Hello everybody and welcome to A.Zalesov and Partners Patent and Law Firm. Let's discuss today Russian and Eurasian patent system as a possible way to obtain patent protection for your technical solution in Russia and maybe in other Eurasian countries. Why it is important to know about not just Russian patent system but also Eurasian patent system. This is mainly because since recently Russia, Belarus, Kazakhstan, Kyrgyzstan and Armenia have joined a single customs and economic union. So nowadays there is an open free market within these 5 countries and the goods can freely circulate within the borders of 5 countries. That is why obtaining protection just by a Russian patent on the Russian national territory maybe is not sufficient for your interests. So, what is Russian and Eurasian patent? Basically, according to the Russian national law, Eurasian patent has absolutely the same legal force on the Russian national territory as a Eurasian patent. So, Eurasian patent can be enforced in the very same way as a Russian national patent. That is why when we speak about the title for an invention in Russia, if it is based on Russian national patent or Eurasian patent, it is just the same. It is true that nowadays foreign applicants mostly use Russian national patent to obtain patent protection for their technical solution. Why is that? Maybe partially this is because of tradition, because Russian national patent system is a successor of the Soviet Union patent system and foreign applicants are just accustomed to use it. But other explanation is that probably there is still a little knowledge about Eurasian patent system, although this system has been practicing for more than 25 years now, since its start in 1995. Okay, let's start with the basics of the Russian national patent system. It is based on the Russian Civil Code, which provides that invention can be protected in Russia by a patent for up to 20 years, and for pharmaceuticals and agrochemicals, after Russia joined World Trade Organization, the law permits to have it up to 25 years to compensate the term required to obtain first marketing authorization on the Russian national territory. You can also protect your technical solution in Russia by a patent for utility model if your technical solution relates to a device. And it is important to know that Russia requires registration for all kinds of licenses, exclusive licenses, non-exclusive licenses, and all assignments related to a patent right. So you should register assignment and license with the Russian State Patent Office. Otherwise, such transaction is considered as void according to the Russian national law. So, if we speak about protection by Russian patent of an invention, what should be mentioned here? First, there are 3 main routes to enter a Russian national patent system for foreign applicants. The most common route is of course a PCT route. When you have a PCT application, you can enter a Russian national phase of a PCT within 31 months from the priority date. And again, this is the most common route to obtain patent protection by a Russian patent. The second option is to file a Russian national application based on your domestic original application and claim Paris Convention within 12 months after such filing. But please note that you have 16 months then to provide a certified copy of a priority document to the Russian Patent Office to preserve your convention priority. And the third option, which is not so often used, is just initial filing in Russia without claiming any priority. Okay, after filing of your application, the application goes into the formal examination of the Russian Patent Office. It takes 2 months, and after that, if you file the substantive examination request, the Russian Patent Office provides a substantive examination over your application. The substantive examination request in Russia can be filed within 3 years after the filing. So it is up to you to choose if to file the request simultaneously with filing of your application, or you can wait up to 3 years from the filing date. During the substantive examination, the Russian State Patent Office checks the requirements of the Russian patent law. The first requirement now is the sufficiency of disclosure. The law requires that the invention should be disclosed in the original materials of application in the manner sufficient to practice it by specialists in the art, and not just practice it, but also practice it with obtaining a technical result claimed. By the way, please note that technical result is a very important part of the Russian patent application. If examiner decides that there is sufficiency disclosure in your patent application, he starts patent search, and after patent search, and of course applicant receives results of patent search, examiner is to decide if the invention is industrial applicable. So it means that you show how to use your invention in industry, healthcare, agriculture, etc. And if it is industrially applicable, then there is a check for novelty. There is absolute worldwide novelty in Russia and inventive step. Inventive step means, of course, that your invention does not follow obviously for a specialist in the art from the prior art. So, after such examination, the examiner decides if he can grant your patent or he must reject it. And the rejection decision of examination can be appealed to the Chamber for Patent Disputes of the Russian Patent Office. If there is a decision on grant, you pay a grant fee and obtain your Russian patent and can enjoy the legal monopoly in Russia, but of course in Russia only. If we speak about prosecution of utility model patent applications, it's a little bit different from the prosecution of invention application. First of all, the substantive examination for such application starts immediately after the formal examination without any further request. And during the substantive examination, the examiner checks if it is properly, sufficiently disclosed in the application, your utility model, and he checks industrial applicability and novelty. There are only two criteria of patentability for utility models, just industrial applicability and novelty. It is also worldwide novelty. Comparing to three patentability criteria for invention applications. The other difference with invention is that application for the utility model can refer just to one utility model. It means that you can have only one independent claim in the claims of your utility model application. Meanwhile, the invention application permits you to have multiple independent claims and multiple dependent claims. And by the way, multiple dependency is permitted in Russia if it does not affect the clarity of the claims. And the examiner is going to check that. By the way, the Russian patent law provides you the possibility to write your claims in quite different ways. So practically all types of claims are acceptable in the Russian patent examination, no limitation, including you can have a functional claiming in Russia as well. So what else can be said about Russian patent system? It is very, very fast now. So it is extraordinarily fast how Russian Patent Office now provides a substantive examination. I would say that according to the last year, the average term of examination, of substantive examination, was about 7 months. Just extraordinary figures. And the same and even higher speed is for checking the patentability of utility models. Okay, as you can see, Russia has a very efficient patent system, and by the way, I can assure you that enforcement of Russian patent can be done also in quite effective manner. Let's switch to the Eurasian patent system. And as I said, currently, since Russia joined a Eurasian Economic Union, probably Eurasian patent is a good option to choose when you think about obtaining protection, not just in Russia, but in other Eurasian jurisdictions. What is Eurasian patent system? Eurasian patent system is based on Eurasian Patent Convention adopted in 1995. Initially, 9 countries were participating in this convention. It was Russia, Belarus, Kazakhstan, Kyrgyzstan, Armenia, Azerbaijan. And initially it was also Moldova, but Moldova left Eurasian Patent Convention in 2002. Old Eurasian patents are still valid in Moldova, but nowadays Eurasian patent application cannot cover Moldovan national territory. So if you decide to file Eurasian patent application, let me explain what is the main benefit of the Eurasian patent system. Eurasian patent system provides you a possibility to have a single title covering 8 countries nowadays in a single procedure. So it's very convenient system to obtain protection in multiple jurisdictions, and it is very cost efficient system if we speak about obtaining protection in several countries. Let me say it this way: if you decide to have at least 2 patents like Russian and Kazakhstan or Russia and Belarus, definitely a single Eurasian patent procedure will cost you less than 2 separate procedures. Why is that? Because Eurasian patent is prosecuted just in Russian language. You do not need to provide any further translations into national language. You do not need to have any validation. You do not need to hire a national patent attorney. You just require services of Eurasian patent attorney to represent you before the Eurasian Patent Office. So the main benefit is cost efficiency. If we speak about examination standard in Russia and Eurasia, I would say that yes, there are some peculiarities in Eurasian patent system, and main peculiarity for the foreign applicants is that you should, if you have a PCT application entering Eurasian national phase, and it is also 31 months term from the priority date of your PCT application, then you have to file your substantive examination request practically simultaneously with the entering regional phase and in Eurasia. But if we speak about examination standards, they are very much similar. The quality of patent search in Eurasian Patent Office is very high, and that is on the same level as in Russia. And Eurasian Patent Examiner is going to check practically the same, with the same attitude, the patentability criteria over your invention. So basically, if you decide what to choose, Russia and Eurasia, regarding the standard of examination procedure, it is just the same. If we check the patentable matter in Russia and Eurasia, it is just the same, and it is very similar to those of provisions of the TRIPS agreement. If we check what subject matter is excluded from patentability in Russia and Eurasia, it is just the same. So practically no difference is between 2 jurisdictions. So again, it is just maybe a matter of costs, of economic effectiveness to choose a Russian or Eurasian patent procedure. So again, if you, or if you are a patent attorney, if your client wants to protect invention not just in Russia but in some other jurisdictions of Eurasian territory, please think carefully about Eurasian patent option. Speaking about timing of prosecution in Eurasia, it's a little bit not so quick as in Russia. So in average you will obtain your Russian patent for invention, let's say, in about 1 year. In Eurasia it will take you 1.5 years, something like that. But still, as you can see, it is quite fast procedure comparing with many patent offices in other jurisdictions. And again, the advantages of costs in Eurasia are high. Maybe one of disadvantages of Eurasian patent procedure is that you do not have an option to choose utility model. In Eurasia, Eurasian patent refers only for inventions. This is true. But if we speak about entering PCT case, it is not very important for you. You can choose invention pattern. So thank you for your attention and goodbye. See you in our next videos. Thank you very much.